Hi, I'm Andy Biggs, Congressman from Arizona's 5th Congressional District. We're getting a redux, kind of my guest is going to give us an update on what's been going on in his world in COVID. So my guest is Tom Hatten. Tom is the founder and CEO of Mountainside Fitness, Arizona's premier and privately owned health club. It currently operates, when it's allowed to, 18 locations with over 1,400 employees and over 100,000 active members. Mr. Hatten's 2018 memoir, Dream On, was a 2019 bestseller on Amazon's biographies of business professionals and business biographies in history. He's been featured on the cover of Entrepreneur Magazine, U.S. News and World Report, Forbes Magazine, and Club Industry Magazine. He's a regular speaker at ASU's W.P. Carey College of Business in both the undergrad and master's program classes. And he's been fighting an honorable fight. And Tom, thanks so much for taking time. It's been a busy day for you, I'm sure.
Thank you. Appreciate it. Yes. Yes.
So Tom, just refresh our recollections of how we got there. It's just for everybody coming on today who aren't aware of this, a Superior Court judge issued a ruling today in a case brought by Tom and I think some others. And so Tom, can you give us an update on first of all, how you got here to this point, and then we'll go from there.
Sure, absolutely. You know, we started really with the first go around was we filed suit against the governor for arbitrarily closing fitness centers, and we felt like that was unconstitutional for various reasons, and that's why we filed the suit. We immediately then also filed a temporary restraining order to allow us to stay open until the suit was heard. That was the first thing that everybody heard about in court, was a temporary restraining order that we met with about 4 weeks ago. When we were denied, however, Judge Thomason stated that the state needed to provide remedies for all fitness centers, in this case protocols, to allow us to open, and those protocols needed to be available before July 27th, which was at the time when Governor Ducey shut us down the second time, said that we were going to be allowed to open. So if you recall, on July 22nd, he then stated that we weren't going to be allowed to open, however, did put up the protocols, but he put them up as a draft only and stated in the protocols, if you sign them, you would not be allowed to open. As you can see, that was quite confusing and frustrating. And therefore, we went to round 2 of the temporary restraining order, which was heard last week, and the judge denied it, but however, continued it till yesterday, where he wanted to hear evidence that we could bring in experts, as the state had with Kara Christ and Marjorie Bennett. And we did that. We brought in 4 experts and provided those to the judge, stated our case and said that we would follow those protocols, but we had to be allowed to sign them so we could open them. And that's what the ruling was today, is the judge said it was basically failure for due process for us to not have those available, and stated that they needed to be available within a week so we can open.
Yeah, and so it's kind of a mixed bag win, I suppose I would say, because the court didn't say that the governor clearly went outside his constitutional authority or statutory authority even. He didn't address that really, because he ruled apparently in the reports I'm seeing, I haven't had a chance to read the case yet, but on 2 issues, procedural due process and substantive due process.
Right.
And I just shot a text message to one of my legal buddies too, and I'm like, hey, when's the last time you remember somebody ruling on a case based on substantive due process? So it was one of these deals where it's a real mixed bag, where on one hand he's saying, you're going to get an opportunity, but how certain is that opportunity if you sign on to these protocols? How certain is it that you're going to even be allowed to open up?
Well, I think with inside, you're exactly right. Is good sleuthing by you to see that there was 2 really, substantive due process and procedural. And the substantive was really the beginning of this process. It said really the governor has full range of authority during an EO process. And that's hard to overcome. We tried to do that certainly in our first temporary restraining order. The procedural due process comes about with the attestation. And that's what they have to do. And that has to go up and be available for us to sign within a week. We cannot be forced to be closed longer than that. And that's what that procedural due process ruling states for us.
Well, and in keeping with that, because you were denied procedural. Let's leave substantive due process out of this for a second. Let's get to the procedural due process. Because you were denied procedural due process, in my humble opinion, that means that the state is responsible for the cost of the taking because they failed to give you a remedy. And that remedy would have been to apply, as which effectively what they're doing now, they're by establishing protocols and allowing you to apply. That's just a back of the envelope. Take a look at this thing. I haven't done any substantial substantive research on this, but when I look at it, I think Arizona's constitution is one of the tightest drawn in the nation on takings, eminent domain issues. Very tight. It's been, in my opinion, it's been misconstrued by courts in Arizona over the years, but it limits very specifically when the state can take any property. And effectively, when they did that, by closing your business, they took your property, and it's outside of that. The judge, at least in some small way, recognized that by granting you a procedural due process remedy. And so what's the next step for you guys?
Well, we're gonna prepare to open as we did on the week of July 23rd or whatever, 21st. We're going to prepare. We're going to get 1,500 people ready to come back to work, and we're going to open on the what is it, the 11th, and we're going to expect, as the judge has ordered, that the state will put up that draft attestation for final signature, and we're going to sign it and open.
Okay,
that is our plan. And
well,
and our heads are spinning. We're relieved. It's certainly been grueling, and we don't ever want to have to go through this again. No business industry has had to been shut down 3 times. There certainly just can't be a fourth, and there just won't be a fitness industry.
Yeah, and I look at it and I say, well, fortunately, you guys are one of the biggest by far in the state. You have other competitors that are smaller that probably just couldn't weather
right
the closures, and that's a real crying shame, because I think so many people were trying to. I mean, last time you and I talked, you were explaining all the protocols, everything you guys put in place, because you were working with the governor's office, and you felt like you were ready to go, and then they pulled the rug out from under your feet.
Yeah, he's exactly right. And, we had really done that during the first closure, so we were certainly surprised that without notice or reasoning or proof as to the second shutdown. And then the continued shutdown was really, really frustrating. There was a lot of things that were put in place when fitness centers were forced to close. There was also bars were forced to close. Ironically, Arizona is not a state with a lot of bars, which are called Series 6 and Series 7s, which means they don't serve food. Very few of those in the state. Today, there's 4,166 restaurant bars still open, which is what most of us are used to, So, those are still open. I think the one thing that's been out there is the mask protocol has been a big difference. And I think just time as the virus has gone through people and been out there in the public. So there's been a lot of factors. I think this particular win in the procedural due process was not only for fitness, but generally in business, in a pandemic, in general, what a governor's authority can be. So businesses cannot take, so to speak, the fall for everything and literally go out of business in the name of a pandemic.
Right. No, I mean, great points. I do know on the Class 6, Series 6 licenses for bars, they've got their own lawsuit going, and I've had a chance to talk to the lawyer there, and I think there's like 64 bars, I think, that have come together in that lawsuit. So I'm pleased that in a way you get a win, you get this. It's not the win that I think should have been there, but it is going to allow you guys to get open again, and I'm happy about that. I mean, literally this morning I was looking at these guys. I want to say it's New Jersey, it's back east somewhere. These guys, they've had their gym closed and reclosed and reclosed. They put the officials put plywood on the windows and everything, and they're ripping it off. And they said, you know what, if we got to go to jail, we're going to go out of business if we don't open. So it's either we open and they take us away to jail and we go out of business that way. So we get on fighting. And so I'm glad you didn't have to go that way, but you did have to go in and fight. I mean, that's this is a different way to fight, but you had to go in and fight this.
We did, and we did stay open during the first, after the first shutdown when we were open for about 3.5 weeks and then forced to close. We did stay open, and that's where I kind of would side with the guys from Jersey who did that, because enough's enough already. The one thing that doesn't get talked about enough, Congressman, is that 100,000 jobs were gone. That's how many jobs in the fitness industry between studios and health clubs. Not to mention 500,000 members displaced. Nobody's talking about that. And that's a big deal when we're talking about the federal unemployment stimulus ran out on July 31st and what's going on out there. 100,000 people lost their jobs. Today they got their jobs back.
Yeah, and that's right. And we don't hear enough about the people who've lost their jobs. They've been displaced. How about consumers? I mean, you've got a clientele that are going to go into gyms. They're trying to stay healthy. They're trying to work out. If they have a health problem, they're trying to get over that. Maybe they're trying to rehabilitate the body, whatever. Mind, emotions, all of those things gyms allow for kind of a holistic healing, and so it's really important to get you guys open. So I'm glad you're opening. I'm glad that Tom, that you guys really kind of took the lead on this with this fight, because it had to be fought, and I wish it hadn't been necessary, but it was.
I agree with you. I agree with you wholeheartedly. And hopefully that's over and we can all move forward together. That is our goal, as we did, several months ago, and not have to go through this, again, ever.
Yeah. Well, I appreciate you taking some time. I know it must be a busy day. A lot of people probably trying to talk to you, and you got to get ready to get open again. I wanted to ask you one last question, because I've heard from other businesses that are trying to open up that they've been having trouble getting employees back. Are you having any trouble getting employees back?
Yeah, I think that's a legitimate point. I think that was, when we stayed open and then it said that we had to close, and it was about 3 weeks. We made a decision to continue paying them just for the possibility of being there, and still have lost some. I mean, when 99% of businesses are open out there, they need to go look for a job elsewhere. And that's the scary part for the fitness industry, is a lot of those employees went and found jobs elsewhere if they were available. So it's going to be hard work. We're going to need every minute to get everybody back and ready to go, and, trusting that we'll be able to stay open.
Well, Tom, hey, thanks for taking a few minutes out. I know you're busy. Get after it. Congratulations. And, if I ever start working out again, you might
know where to go. Thank you so much, Congressman. I appreciate it.
Yeah, Tom, you have my support. Keep fighting, man.
Appreciate it.